This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. Please subscribe to my channel, and if you have an immigration problem, get in touch with me. Today I'm going to be talking about a case which not only gives asylum seekers the right to work, but also extends it to their dependents. This is a major change. It follows on from an intervention from the courts in the case of OH versus the Secretary of State for the Home Department. And it concerned the rights of a dependent of an asylum seeker to work in the UK. What this means in practice, I'll go into the law in a minute, is that it's not only asylum seekers but now the dependents that can or will have the opportunity to work in the United Kingdom. It's a very good decision given the particularly long delays in processing asylum claims. Indeed, I'm challenging a 4-year delay in processing or even getting an interview for someone with mental health problems. The facts of this particular case were that the applicant was dependent on his wife's asylum claim and challenged his refusal for the right to work. His wife and the applicant were both medical professions. After the applicant made several unsuccessful asylum claims, his wife then made an asylum application and he was her dependent. Neither of them met the requirements of permission to work under the immigration rules, so they asked the Secretary of State to exercise her discretion instead. The wife was granted the right to work, but the applicant wasn't. The court then confirmed that the Secretary of State did not need to exercise discretion when considering an application for right to work for the purposes of Article 8. The guidance itself confirms that the immigration rules do not provide for dependents of asylum seekers to work even if their claim has been outstanding for longer than 12 months. However, it is difficult to see why a caseworker should restrict the guidance to primary claimants for asylum and fresh claims only, and not extended to dependents. There is no other guidance available for those without current permission to work, and the guidance already clearly indicates significant space for their right to volunteer. The court therefore found that the policy, as it would be understood by caseworkers, would apply to dependents of asylum seekers as well as the primary claimant, so that dependents may have exercised discretion in their favour. In essence, it ultimately falls for the Home Office to draw a line on who is entitled to access the local labour market. Adopting a restrictive approach to dependents of asylum seekers is a legitimate reflection of these policy objectives as well as within the ambit of Article 8. Unfortunately for the Secretary of State in this particular case, the Secretary of State lost. So, in short, if you are the dependent of an asylum seeker, there may well be the opportunity for you to gain the right to work as well as the main applicant themselves. So, good news in this particular case, and it's thanks to the courts that this decision has come out. I hope you've enjoyed watching this video. If you have any problems, please do not hesitate to contact me. This is Paul Turner, the Immigration Barrister at Imperium Chambers.